Hello, hi, I am Sridhar. Welcome to my channel Justice Bench. Today I am going to discuss about what is a false FIR and how to get rid of a false FIR and what are the remedies available in Indian Constitution. Let's proceed. So before understanding what is a false FIR and its remedies, let's understand what is the FIR itself. FIR is nothing but a formal complaint taken by a police officer will be registered as a first information report. So it is the initial step in a criminal proceedings against someone which is lodged as a first information report. So basically what are the ingredients of a complaint and how it is treated as a FIR? Let's get into it. So let's assume some person A is living in Bombay, had lost his wallet at 4:30 p.m. on 27/11/23 in metro station, which was thefted. Some unknown person. So this is the incident happened. So the person immediately has to approach the police station where the metro station have the proper, where the police station have the proper jurisdiction of the metro station. So the person has to clearly indicate the time, the date, and the metro station details, and how it was lost, and by whom, whether the person is known or unknown, and in which direction he left or he ran away. So it need to be very detailed about the incident and how it happened, at what time, and all these details need to be mentioned in an FIR. After that, the police will take this FIR, this complaint, and they will file the first information report based on this complaint. So after this, the police will take necessary action accordingly. So, an information of a cognizable offence committed can be registered by a person to police under section 154 1 of 1 of CPC 1973, and it is known as the first information report. So let's understand what are the other elements need to be considered while registering the FIR. So a crime can be compoundable or it can be a non-compoundable crime. It could be a bailable or non-bailable offence. It could be a cognizable or non-cognizable offence. See, in the sense, compoundable or non-compoundable means a crime can be withdrawn or compromised, or it could not be not compromised. A crime can be bailable or non-bailable. So some of the minute cases like pickpocketing, thefting, 498 A, and some other cases just need a station bail, and the persons can come out taking the station bail. But there are some other heinous crimes like murder or rape, where judicial remand would be up to 90 days to 60 days. In some cases, it is only 15 days. So it all depends on the nature of the crime. So it has to be the person who against whom the FIR has been registered. They need to check all these possibilities, whether they have to take the bail or not take the bail, whether they have to go for the anticipatory bail, default bail, depends on that. If the condition of the person is not at all very proper or having some health issues, he can opt for the medical bail. So other thing is like cognizable or non-cognizable. Now the question comes whether the police can take the complaint of each and every crime and file a FIR report. The question is no. Why? Because there are certain crimes where the police can take the complaint and file the FIR. There are some cases where magistrate has to take the file complaint and file the FIR. In such cases, example 499 and 500 of I.P.C. In these two cases, this is a defamation case where police cannot take cognizance of them, but a magistrate can. So the person has to who is going to file the complaint, they should have the proper understanding or maybe get properly guided at the time of filing the complaint. So what to do if police do not register FIR? So this is the common problem faced by many people when police are not registering the FIR and they keep on moving around the police station and their grievances are not getting registered. In such cases, what are the remedies available? Let's see. If the police do not register the FIR or refuses to register the FIR under section 154 of CrPC, then the victim can file an FIR to a senior police officer or SP under section 153 154.3 of CrPC. Let's say let's say the police are not taking the FIR complaint. The first remedy would be to file complaint to SHO of that police station, SHO of that police station via registered post. Okay, so wait for 24 hours. Wait for 24 hours after police receive the complaint via RP, and even after 24 hours there is no appropriate action taken by them. So the next step would be appropriate would be to file complaint to SP via RP registered post again and wait 24 hours after receipt of complaint. Receipt of complaint by SP. So in either cases, that means the case 1 and case 2, neither SHO nor SP, both of them has received complaint via both of them has received the complaint via registered post and it is acknowledged. Okay, but 24 hours has lapsed. Here also 24 hours has lapsed, and for the postal and all that, another 2 to 3 days has taken place. Even after lapsing of all this time, what is the remedy for the person is to approach the court. Now, if the FIR doesn't get registered by the senior police officer or superintendent of police under section 154.3 of CrPC, then person can approach the magistrate and give the information about the cognizable offence committed under section 156.3 of CrPC, after which the magistrate would direct the police to start the investigation and register the FIR. So this is the appropriate way to get your FIR registered. So don't waste your time moving around the police stations for months or years. The simple way is like you have the you have your complaint and you can directly give it to SHO of the police station via registered post. After receipt, wait for 24 hours. Again, do the same for the superintendent of police. After that, approach the magistrate. Magistrate having the jurisdiction of that area. So now coming to the actual topic, what is false FIR? So false FIR means it is very common that these days many persons are deliberately lodges false FIR against someone in order to falsely implicate him or her in a false case, generally because of enmity. So this is very common scenario happening here and there. So you people or the other people might be observing it. So to to fulfill their vicious ambitions, and to victimize someone, they use FIR as a weapon to unnecessarily suffer the other people. So these kind of false allegations and other vexatious allegations are considered as the false FIR. False information is information which has been given deliberately with an intent to deceive. Deceive means mislead or misappropriate. Mislead. So what are the remedies against the false FIR complaint? Let's get in more detail. So remedies against false FIR complaint means remedies provide in our legal system for a person against whom a false implicated case is lodged. Number one, remedy before arrest is made. That is anticipatory bail. So in that case, if a person believes, let's assume a person A is falsely implicated in a false case and a FIR has been registered against him or yet to be registered against him, then he can opt for anticipatory bail. So he need to convey what are the circumstances and how he is not directly involved in the crime, his background, his good nature, and convince the judges he is nowhere related to the crime. So remedies after arrest or filing of charge sheet before the court. What if FIR is already registered and in that case the person has to offer default bail. Once FIR is registered, the remedy would be default bail. So next is quashing of FIR. What is the way and how to do it? Remedies after getting acquitted from the falsely implicated case. Once the false case is proved and that case got quashed, what are the remedies and how that person can be compensated from the provisions of the law? Now, compensation for acquisition without reasonable cause. Filing a civil suit for damage, defamation, yes, as the person is living without living very peacefully in the society, having very good reputation. Because of this false case his reputation has been damaged. That person can go for the defamation against the person who has filed a false case against him. Now penal provisions for persons lodging false FIR. Yes, there are penal provisions under 211 of I.P.C. They can be punished. So next, anticipatory bail before arrest is made. Now, the object of Section 438 is that a person should not be harassed or humiliated in order to satisfy the grudge or personal vendetta of the complainant. The court held in HDFC Bank Limited versus J.J. Manan alias J.M. John Paul. In this case, the court has clearly held that. So, the object of Section 438 is that a person should not be harassed or humiliated in order to satisfy the grudge or personal vendetta of the other persons. So if a false FIR gets lodged against a person for a non-bailable offence, then person to circumvent the police custody can apply for bail under Section 438, that is anticipatory bail of CrPC, before the Sessions Court or High Court before arrest is made. So the provisions of Section 438 cannot be invoked after the arrest of the accused. That means once the FIR has been registered and arrest is not made, then only the anticipatory bail provision is applicable under Section 438 of CrPC. But if person is already arrested, then what? He has to opt for default bail. That's the difference. So it is not proper to think of anticipatory bail in all these circumstances, only if the person is not arrested. If the accused must seek his remedy under Section 437 or 439 of CrPC if he wants to be released on bail in respect of offence or offences for which he is arrested. And this has been clearly stated by the Honorable Court in Rashmi, Rayaka, Toti and others versus State of Orissa and others. Anticipatory bail before arrest is made. However, the order made by the Court of Anticipatory bail can only become operative on arrest being made, or while granting anticipatory bail, the respective court makes the order to release the person on bail in case of arrest. The provision of Section 438 of CrPC states that where the High Court or the case may be, the Court of Sessions has rejected the application for the grant of anticipatory bail, it shall be open to an officer in charge of the police station to arrest, without warrant, the applicant on the basis of the accusation apprehended in the such application. So it is clearly iterated that if a anticipatory bail application is rejected, the police officer in charge can arrest that person without the warrant on the basis of the accusations apprehended in such application. So if that person is not getting the anticipatory bail and he is present in the court and police officer in charge is also within the premises, there are chances that that person may be arrested anytime outside the court. Quashing of FIR. So the most important thing is now the false case has been registered. How to come out of this? Now that provision has been 482 of I.P.C. Inherent powers of High Court under Section 482 of I.P.C. So next is quashing of the FIR. So if you come to the quashing of the FIR, so the inherent power of the High Court under Section 482 of CrPC laid down that the court has power to stop or prevent the abuse of the court process or any other person from the who has been falsely accused. For that reason, a person can directly approach the High Court of the state where he is residing and file complaint under Section 482 of CrPC and pray for the court, pray to the court for quashing of the FIR. So is that so easy? No. The answer would be good no. But the Supreme Court has laid down some proper guidelines on what basis the court can consider quashing of the FIR. So the guidelines laid down Supreme Court are that there is no prima facie case, in the sense there is no, by reading the case itself someone will understand that there is no crime committed by someone. Abuse of absence of cognizable offences, that means there is no cognizable offence has been committed, so that would be the another ground. Commission of crime not disclosed, whether there is a simply FIR but it does not discloses what the person has committed actually. Investigation begun without the order of the magistrate in non-cognizable cases. It is very important for the police to take the order of the magistrate before they begin the investigation in non-cognizable cases. But if the police violate this rule and they, without taking the permission of the magistrate, begins investigation, then it would be a ground to quash that FIR under 482 of CrPC, and there is no evidence against that person. Legally barred means legally it is prohibited. For example, if you take an insane person, so under Section 84 of I.P.C, if a person is insane, so they are barred from the punishments. So there are some other crimes which are legally barred. So vexatious proceedings means the proceeding itself has not followed any rule of law and they have committed some crime. Let's say like the station house officer has manipulated station diary or not followed procedure to arrest the person or lodge FIR. So there are many irregularities while registering the complaint, and these are all can be seen by Prima Facie. So in that cases, those FIRs can be quashed. So other things like the Constitution of India under Article 226 has given uh, two exclusive writ provisions, that is prohibition and mandamus. So one can seek for mandamus or prohibition for squashing of the FIR before the Honorable High Court of the state. Inherent power of High Court under Section 482 of CrPC. So what this section speaks about? Under Section 482 of CrPC, vested the inherent power of the High Court to make such order as may be necessary to give effect, again to give effect to any order under this code, or to prevent abuse of the process of any court, or otherwise to secure the ends of the justice. So any case, any abuse of process of the court is been happening by the way of false FIR, or maybe to meet the ends of the justice, to secure someone from the injustice. So this inherent power can be invoked by the High Court under Section 482 of CrPC. The High Court inherent power both in civil and criminal matters. It is not only limited to the criminal matters, but it also extended to the civil matters, is designed to achieve a salutary public purpose, which is that a court proceedings ought not to be permitted to degenerate into a weapon of harassment or persecutions. It is very clear that a provision has been laid down against the weapon of harassment or persecutions. If any person is facing issues, they can invoke the inherent power of High Court via writ petition, the way of prohibition or mandamus. Inherent power of High Court under Section 482 of CrPC. Hence, if the High Court is of the opinion that there is no prima facie, that means in the crime committed, if there is no prima facie ground made against the accused, means there seems to be no crime at all against the person, and complaint lodged against the person is vexatious, then the Honorable High Court, using its inherent powers vested under Section 482 of CrPC, may quash the FIR. That is very simple and clear. Guidelines to quash the FIR under Section 482, which were laid down by the Supreme Court, that is, in the state of Haryana and others versus Bhajanlal and others. The Supreme Court held that in this particular case, it may not be possible to lay down any precise, clearly defined, and sufficiently channelized and inflexible guidelines or rigid formulae, and to give an exhaustive list of myriad kinds of cases wherein such power should be exercised. No prima facie. So, what is the meaning of no prima facie? When the allegations made in the first information report or complaint, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute any offence or make out a case against the accused. So, even though the complaint has been given, but there is no prima facie, means there is no offence has been committed by the person. In that case, it constitutes to no prima facie case. Means when the crime itself is not committed by the person, simply for the mere sake of registering the FIR, the SHO has registered an FIR to suffocate someone, and that person has not committed any case, means like not any crime. In that case, there is no prima facie, and it is eligible for quashing under Section 482 of CrPC. Absence of cognizable offence. So, where the allegations in the first information report and other material, if any, accompanying the FIR do not disclose a cognizable offence justifying an investigation by the police officer under Section 156(1) of CrPC, except under an order of a magistrate within the preview of Section 155(2) of CrPC. So that means that even the material that are accompanying the FIR and the other supporting documents, even all of them has been provided, but that does not disclose any cognizable offence. Means there is some, like there is an incident has happened between two neighbors, and there is only shouting, but there is no offence has been committed by neither of them. Means abusing anybody or maybe shouting at any other person does not happen, but there is only a shouting in loud noise has happened, but nobody has offended nobody. But that shouting does not constitute to FIR because there is no cognizable offense has occurred. Commission of crime not disclosed means where the uncontroverted allegations made in the FIR or complaint and the evidence collected in support of the same do not disclose the commission of any offense and make out a case against the accused. Means example like the consider the previous example, like if you are taking two neighbors, they were just shouting, but none of them abused neither persons. They were just shouting, and this does not constitute a crime. So, and it cannot lead to the offense. Investigation begun without the order of the magistrate in non-cognizable offences, where the allegation in the FIR do not constitute a non-cognizable offence, but constitute only a sorry. Investigation begun without the order of the magistrate in non-cognizable offence, where the allegations in the FIR do not constitute a cognizable offence, but constitute only a non-cognizable offence. No investigation is permitted by the police officer without an order of the magistrate, as contemplated under Section 1152 of the Code. Lack of evidence, where the allegations made in the FIR or the complaint are so absurd and inherently improbable on the basis of which no prudent person can ever reach just a conclusion that there is a sufficient ground for proceeding against the accused. Legally barred, where there is express legal bar engrafted in any of the provisions of the code or the concerned act under which a criminal proceeding is instituted to the institution and the continuance of the proceedings, where there is a specific provision in the code or the concerned act providing efficacy redress for grievances of the aggrieved party. Vexatious proceedings, where a criminal proceeding is manifestly attended with a malified and where the proceeding is maliciously instituted with an ulterior motive for weakening the vengeance, wreaking the vengeance on the accused, and with a view to spite him due to private and personal grudge. Constitution of India. When a false FIR is lodged against the accused, and a police officer or government servant knowingly registers such FIR, and when the subordinate court passes any order against the accused, in mistake of facts or ignoring the above facts, then the person aggrieved can approach the Honorable High Court under Article 226 of the Constitution of India to file a writ petition, and High Court may, after getting satisfied that there is a grave injustice taking place, the High Court may pass a writ of Mandamus or Prohibition. So the writ of prohibition can be passed by the High Court to subordinate court under which such vexation is going on to stop such criminal proceedings. So in cases where there is a criminal proceedings are happening with vexatious ambition and the victim is suffering and he has proper evidence and the subordinate court has overlooked the facts and giving the wrong order, then that person can approach the High Court to invoke prohibition and get the order against that false FIR. Next is Mandamus. The writ of Mandamus can be passed by the Honorable High Court to order the police department or to the police officer who has lodged false FIR against the accused to perform their duty legally. The Mandamus against the police officer before the at the police station stage before going to the court, and the prohibition is against the court or to the subordinate court. So you need to be cautious to pick which one based on the circumstances you are lying. Remedies after getting acquitted from the falsely implicated case. So after getting the false FIR quashed by the court through above mentioned legal procedure, the person against whom false case was made can get the following remedies. Compensation he can get, and he can file for the civil defamation. So let's see what is compensation for accusation without reasonable cause. That means a person is accused without reasonable cause. What compensation he is likely to get? Section 251 of CrPC lays down the provision that a magistrate, while acquitting the accused, thinks that there was no reasonable ground for making the accusation against the accused person, he may order the person making such false accusations to pay compensation to the accused person. Yes, that person is likely to get the compensation. So clause 2 of section 250 also states that amount of compensation shall not exceed the amount of fine magistrate is empowered to impose. For example, in a case where the compensation means where the fine is rupees 10k, so the compensation for the accused or the acquittal is not more than 10k. So this need to be remembered. Filing a civil suit for defamation. So once a false case against a person is generally done by people to defame and torture the people. So when the false case itself is registered, that person is generally they are defamed. So with whom they are having grudges and enmity. Even after getting acquitted from the case or that case being quashed, the person goes through humiliation of character assassination in the society. So as he is being humiliated, hence such a person can file a civil suit under Section 19 of CPC, Section 19 of CPC for compensation of his defamation from the complaint of false case. So penal provisions for persons lodging false FIRs. What are the penal provisions? What are the criminal consequences? A false complaint filed by the complainant. So the person lodging the false FIR liable for punishment under following provisions. So under section 182 of I.P.C, they can be punished, and this can be invoked by the police officer or the officer in charge. So if he is this police officer, maybe public or public servant or any public servant is not invoking the provision of 182 I.P.C, then the acquittal himself can invoke the section 211 of I.P.C with intent to injure. So framing of incorrect documents by the public servant to cause injury under section 167 of CPC, which amounts to contempt of their lawful authority, means if a police officer is if a police officer is making a false case against you, that police officer is also liable for punishment under section 167 of I.P.C, criminal defamation under section 499 and 500 of I.P.C. We already discussed about the defamation suit, but there is also clear provision for filing a criminal case, that is 499 and 500 of I.P.C. False information under section 182 of Indian Penal Code. According to this section, if a person gives information to magistrate or police or any other government official which he knows to be false, with intent to cause that public servant to take such action which cause injury or annoyance to any person, shall be punished with imprisonment up to 6 months or fine up to 1000 rupees or both. So that means as per 182 of I.P.C, that person is likely to get 6 months of imprisonment or 1000 rupees of fine or both of them. False charge of offence made with intent to injure under section 211 of I.P.C. According to this section, if a person with intent to cause injury to any person institute a criminal proceedings or falsely charges any person if an offence knowing that there is no sufficient ground for criminal proceedings or charges, such a person shall be punished with imprisonment up to 2 years or fine or both. This is more serious in the nature of punishment. If such criminal proceedings be instituted on a false charge or offence which is punishable with death, imprisonment or life or 7 years or more, then the person making such false charges shall be punished with imprisonment which may extend to 7 years or shall also liable for the fines. In case the false case of nature of murder, but there is no such incident of murder has happened. In these cases, the punishment for the acquittal would be could have been like around like 7 years or whatsoever because of the false charges. But as the person got acquitted, so the complainant who has filed the false FIR will be liable for the punishment of 7 years or fine or both. This is very serious. Framing of incorrect document by public servant under to cause injury under section 167 of I.P.C. This means that, so according to this section, any public servant, it is not just the police, any public servant, maybe it's a revenue department or some other police department, irrigation department, submits a false document with intent to cause injury to any person, that false document shall be punishable with imprisonment up to 3 years or fine or both. Criminal defamation under section 499 read with 500 of I.P.C. Apart from the above remedies, the person against whom the false FIR was lodged, after getting acquitted from that false cases or after getting FIR quashed, can file a criminal defamation case against the person who has falsely implicated him in the previous case. He or she shall be liable for the punishment up to 2 years, fine or both. So that's the end of our uh, today's video. If any of you have any queries, please email me to justicebench09@gmail.com. Thanks for watching my video. Please don't forget to subscribe, like, comment and share. If you have any doubts, you can put all the doubts in the comments. I'll be with pleasure. I'll be replying to all your comments or questions in the comment section. Thanks for watching my video. Bye.